Today we're talking about a serious traffic infraction called reckless driving. This is something that is very common in Arizona, and it is quite serious. So we're going to talk about the statute, some examples of where we see this most commonly charged, and then what some of the best offenses are. So let's start at the top. In Arizona, reckless driving is defined by statute 28693A. Plug this right into Google, you can take a look at it, and this is what the statute says. It's very, very short. We use this to our advantage, but let's dive into it. It says that a person who drives a vehicle in reckless disregard for the safety of persons or property commits reckless driving. So let's look at that again. Reckless disregard for the safety of persons or property. What does that mean? It's up for a lot of interpretation, and so we're going to explain how that can be used as a defense. But before we jump into that, let's take a quick look. We see this most commonly in these types of situations. So most frequently, it's very fast speeds. So people will be charged with criminal speeding or excessive speed, and the police will also tack on a reckless driving charge. Usually this is in certain jurisdictions where officers like to write it, but in many cases it'll be when somebody's traveling in triple digits or very, very fast into the triple digits, things like 110 miles an hour or something like that. Certain officers, and we keep a list of all these guys, certain of them like to charge reckless driving for those speeds, for triple digits, for any speed over 110. They will tack on the reckless driving charge because according to them, that speed is a reckless disregard for the safety of persons or property, for the well-being of these two items. The other way that we see it is when there's passengers in the car. So if somebody's driving quickly, if somebody is swerving or doing something like that, and they've got a young child in the car, they've got an elderly mother-in-law, or just their brother or their sister or significant other, police will say that is a disregard, driving in that manner is a disregard for the safety of that other person, and therefore that is a violation of the law. That constitutes reckless driving. Another way that we see it is when somebody is driving and they're committing multiple different civil violations. So say, for example, somebody's driving, they are following too close, they have an unsafe lane change, they're also speeding, they're doing a bunch of different things together. So they're kind of weaving in and out of traffic and they're violating a bunch of different laws. All of those may be civil on their own, but when you combine them together, that may constitute reckless driving. An officer will say that type of driving is reckless. The final way that we see it is when people are really not abiding by any of the traffic rules. They're driving off-road, they're cutting over corners, they're driving up on sidewalks or something along those lines. The vehicle driving in a manner that's not allowed under the law, if it's not a road, if it's not something that's a sidewalk, or if it's a sidewalk or something where the vehicle is actually going to be damaging other property as it's driving, that's a reckless driving. That's reckless because it's disregarding the safety, the well-being of that property. So those are the four main ways that we see it. Now let's talk about what some of the defenses are. So as I mentioned previously, it's not a very broad statute. It's actually very short. This is it. The rest of the statute is talking about penalties, what happens if you've been charged with a second offense, reckless driving, and there's a lot of other certain items that you can look at if you've been charged with it. But this is the law. This is what you have to violate in order to be convicted of this or in order to be charged with reckless driving. And it's very, very short. So the first main defense is just to point out the fact that this is extremely subjective. What reckless disregard means to me may be very different than somebody else. So my mother, for example, would say almost everything I do in the car is pretty reckless, whereas my business partner yells at me for going anything, basically at the speed limit or anything right around there because he drives a little bit more quickly than I do. So that's where I'm saying it's very subjective. So what my mom says is reckless is going to be different than what my business partner says is reckless, which is going to be very different than what I think is reckless. So it's very subjective. There's going to be a lot of different ways to interpret what is reckless disregard, what is disregarding the safety of people or property. That's number one, and we can use that to our advantage. The next thing that is very important in a reckless driving charge is that if this case goes to trial and we have to answer the question of what constitutes recklessness, that's up to a jury to decide. Unlike a lot of other civil or criminal traffic violations, a reckless driving charge is jury eligible, meaning you can get a jury of your peers to listen to the facts of the case and then issue a decision, render a verdict as to whether or not this constituted recklessness. And quite frankly, it's not as easy as it may sound. As easy as it may sound, many people will sit on that jury, and we've done trials for reckless driving where people will look at the actions, look at the allegations from the police and say, this is not reckless. I've done that. Okay? That's not reckless at all. And so you can win cases, you can get not guilty verdicts by taking a case to trial because you get a jury of your peers who can take a look at the case. The other thing is that it's very vague. As I mentioned earlier, this is very vague, and jurors in general, they don't like vague laws because that can happen to anybody. If an officer thinks that something was reckless, but somebody else does not think it's reckless, how do you define that? What does that law actually mean? What is a reckless disregard? Well, it's very difficult to define that, and many people, jurors, don't like that. People want to know what constitutes a violation of the law. Like in a DUI case, if you're over a limit, you know what that number is. All right, in an assault case, you know what action is prohibited under the law. You can't punch somebody in the face. We know that. But what is a reckless disregard for the safety of persons or property? We don't really know what that is. It's not very clear. It's not very defined. And so if your case is a jury-eligible offense, meaning this does go to a jury trial, your case is eligible, it's very vague. Jurors don't like that. The final thing that we can look to in many of these cases, especially in the cases where there's passengers, is what do the witnesses say? What do the other people in the car say? Did they feel like the driver was driving recklessly? Did they feel like their husband or their wife or their mother or their father was driving in a manner that actually put them and their property in a state of being harmed, or was it a reckless disregard for their safety or their well-being? In most cases, the witnesses, the passengers, other people who were around when this happened will say, no, it wasn't reckless. I felt perfectly safe. And so you can take all of these factors and you can use that to your advantage. A lot of courts, a lot of prosecutors, a lot of judges, they don't want to take these cases all the way up to a jury trial. You can imagine it's a very, very long process, and you get a lot of kind of wiggle room. There's a lot of variance as to whether or not a jury is going to find you guilty of that. So this is where the defenses are built in. We can use a lot of this to our advantage and say, look, we understand that our client was charged with a crime. We obviously don't want to plead guilty to this offense. This is a Class 2 misdemeanor and has 8 points that would go on your record. It's very serious. And so if we can negotiate this down into something else, we might be okay with that, depending upon what your goals are. And so we can say we're going to use all of this. We're going to use all of these threats, a threat to a jury trial, as leverage to say, let's all make this go away. Let's reach an outcome that everybody in the room is happy with, and we can just close this case out and move on. And so if you've been charged with reckless driving, it's important to remember this is a serious offense, 8 points. It's a Class 2 misdemeanor. It goes on your record, and it can cause a license suspension. If you get a second offense, you can get jail time, mandatory jail time. If you're in a bad jurisdiction with a bad judge, they may ask for jail time, depending upon your speed and depending on the allegations here. So it's important to understand what you're being charged with. These are just some of the defenses that we use regularly. You can imagine there are many, many more, and they're all specific to your case. So give our office a call. If you're watching this video, you may have been charged with this. Come into our office, sit down. We offer a free case evaluation. We'll put together a plan that you can use to make sure that this is not going on your record, and you can move on and move forward with your life. Thanks for watching.